Respectfully, this is an unsupportable argument. It's not necessarily true. Because it is not possible to directly place the proposed duty inside Category 3, the appellants assert that it is necessary to look at the duty in light of the three factors that underlie these three categories.
You may be getting to that later in your argument, but this only gets you so far. If we find that there's no established category, of course, we have the power to create a new one.
Correct, and that's the analysis I will proceed with.
Okay.
The three factors identified by Chief Justice McLaughlin at paragraphs 38, 39, and 40 have been referenced as recently as this year by the Supreme Court of Canada in their decision in Filoka and Pinkerton at paragraph 27. The three factors identified by the Supreme Court are: 1, the defendant's material implication in the creation and control of risk; 2, concern for the autonomy of persons affected by the causative action proposed; and 3, theme of reasonable reliance. Applying these principles to the facts of the current case, the appellants assert that because the fundamental nature of the activities the patron was engaged in were not inherently risky or dangerous, because they were a mere pedestrian, that it is not sufficient level of risk creation between the defendants and the plaintiff to warrant imposing a duty of care, due to the inability to establish proximity. In the current existing duties, the nature of that person's activities was drinking and driving. That is unquestionably serious and unquestionably dangerous. Someone acting as a mere pedestrian does not have introduced inherent risk, even if they are intoxicated.
But it seems to me that at one point, especially the commercial host needs to know what duty falls upon it. And you don't know at this point whether someone you're serving liquor is going to drive, walk home, crawl home. So it seems at that point, how do you define what your duty of care is? I thought the whole point was that you had a duty of care, that they don't get intoxicated. Why? Because these people can leave your premises, you no longer have control when they leave, and they may well take their car and hit a highway user. That's the problem with this. You say it's pedestrian, but at the time where the commercial host has to determine what's my duty, I have a duty that these people not get too intoxicated because I'm the one who's serving the liquor.
Yes, I believe there is a current, pardon me, the appellants assert that there already exists a current duty to ensure that patrons are not overserved if they become intoxicated, and not to serve the patrons beyond the point of intoxication. That duty exists for the purpose exactly that you have stated. Because a commercial host does not know what behaviors a person will engage in after they leave that facility, it is in their interest and it is their responsibility not to overserve patrons. The additional duty imposed by Stewart is in recognition of the particular dangers and particular risks that drunk driving add to our society.
Well, those were the facts in Stewart, but now the facts here is another danger. The person might use a mug to harm someone. It's not just another way that the danger is manifested.
Well, at the duty stage, we are focused on some harm rather than specific harm. So the specific facts of the mug would be a standard of care issue. At the duty level, we are focused on the behavior of that patron and whether it introduces risk between the defendant and the plaintiff. And we argue that the simple act of walking does not do so. In the order of being mindful of time, I would like to proceed to policy arguments. Thank you. The appellants assert that even if a prima facie duty of care is found, that the prima facie duty of care would be negated by policy concerns. Most specifically, the appellants assert that in giving rise, if the duty was to be expanded as proposed by the appeal judge, the defendants would be exposed to indeterminate liability. Because the effect of expanding the current duty to all third parties who are not users of the highway would open up a potential class of plaintiffs that is not just large, but indefinably large. The issue is not, the concern of my client is not that it would be large liability, but rather the sheer number of interactions that occur between patrons of a facility and third parties cannot be quantified, would thus put them in a position of being faced with potential indeterminate liability. Without creation of, pardon me.
So is that what we mean by indeterminate? Because it seems you've got a fixed number of patrons. If you watch them, they don't get too intoxicated. There's a limit. I mean, the effects of alcohol will subside. There is a finite number of people they will interact with in a way that could be risky.
The appellants assert that if the duty is created as it is defined, it opens up the liability to the plaintiffs, to the defendants, to all persons, all third parties with whom their patrons interact. That class is not determined. Because that class is not determined, the appellants argue that the liability to which they would be exposed is indeterminate, and thus is not possible for them to guard against or insure against. The Supreme Court of Canada in Canadian National Railway and Norse expressed their aversion to indeterminate liability. I will not reference a specific quote, but simply request the court to keep this in mind.
On the policy issue, shouldn't the policy be to prevent intoxicated patrons from leaving commercial establishments and causing harm? Shouldn't that be the policy the court should follow?
The appellants assert that that policy is already imposed by the existing duty of a commercial host not to overserve intoxicated patrons and not bring those patrons to that point. This additional duty that is being imposed, as suggested, we believe will give rise to, the appellants assert will give rise to indeterminate liability.
Must be late in the day, but I'm having trouble with that because if you already have a duty not to overserve, what's the problem with trying to further restrict what kind of harm we might be looking at? Just don't overserve, period. So I'm not quite clear.
The appellants assert that that existing duty is in place to ensure that they are behaving in a responsible manner to broader society, which is a different scenario than what is being proposed here, which would hold them liable to every person with whom a patron interacts, regardless of the nature of the activities the patron undertakes. Again, with a mindful eye to the time, I would like to briefly summarize my position, the position of my client.
Yes.
In closing, the appellants argued that the proposed duty of care between commercial hosts and third parties who are not users of the highway should not be established. The appellants assert that the proposed duty does not fall within, nor is it analogous to, any previously established duty of care. By undertaking a complete man's analysis, the appellants argue that there is insufficient proximity to establish a prima facie duty of care. Furthermore, even if a prima facie duty of care were established, it is argued that policy considerations would negative that prima facie duty of care. For these reasons, the appellants urge this court to grant an order varying the judgment of the Court of Appeal in British Columbia and negating the duty of care imposed on commercial hosts. Madam Justice Saron, Justice Smith, Justice Hackland, I thank you very much for your time.
Thank you very much. Yes, the respondents are ready to proceed.
Good evening, Justices. My name is Saron and I am counsel for the respondent. I'd like to introduce my co-counsel, Ms.